Okay, so now naman, let's talk about justifying circumstances. So justifying circumstances are circumstances attendant, meaning in addition to, the commission of the alleged offense, which by their presence negates the unlawfulness of the act so committed. Meaning, justify niya, yes, there was a crime committed, but when it is coupled with justifying circumstances, it negates the offense. Meaning, wala nang offense. So that such person is deemed not to have transgressed the law and is free from both criminal and civil liability, except in the case of paragraph 4 of Article 11 of the RPC. So if you check Codal, this is the article that enumerates justifying circumstances, which is the avoidance of greater evil or injury, wherein the persons for whose benefit the harm has been prevented shall be civilly liable in proportion to the benefit which they have received. So kapag yung crime attended with justifying circumstances, yung offender is not criminally or civilly liable except dito sa avoidance of greater evil or injury. Pero yung shoulder ng civil liability is not even the offender but the person who benefited from the act of the offender. So the basis for these circumstances is the lack of criminal intent, and since actus non facit reum nisi mensit rea, which means an act does not make the doer guilty unless the mind is guilty, therefore, there is no crime and no criminal in justifying circumstances. So nananegate niya. And wala talagang crime. Hindi mo matatawag yung offender as a criminal. Hindi siya pwedeng ma-convict. Hindi siya considered accused. Legal yung ginawa niya. So the offender acted in accordance with the law and therefore had not transgressed the law. The offender who has the burden of proving his entitlement is free from criminal liability. Again, yung nag-prove ng justifying circumstance is of course the offender or the accused. The offender has the burden of proving his entitlement to such justifying circumstance, and if successful siya, then he shall be free from criminal liability and civil liability. So, ano yung mga justifying circumstances? So first is self-defense. This is the defense of person, rights, and property. So yung requisite is, first, there must be unlawful aggression on the part of the victim. Second is that there is reasonable necessity of the means employed to prevent or repel it on the part of the offender. And that there is lack of sufficient provocation on the part of the person defending himself. So mamaya, iisa-isahin natin yan. Next is defense of relatives. Of course, yung una, self-defense. Yung pangalawa naman, defense of relatives. Who are the relatives covered? The spouse, ascendant, descendant, legitimate, natural, or adopted siblings, mga kapatid. Relatives by affinity in the same degree, such as parents-in-law, children-in-law, and siblings-in-law. And lastly, relatives by consanguinity, meaning by blood, within the fourth civil degree. So again, asawa, kailangan legal, kailangan hindi live-in partner lang. Ascendant, pwedeng parents, grandparents, pataas. Descendant, pwedeng anak, apo, ganyan. Pagkapatid naman, pwedeng half-brother mo, pwedeng adopted sister mo, ganon. So, pwedeng legitimate, natural, or adopted siblings. Yung relatives by affinity, pwede. Pero, by affinity meaning yung mga in-laws. Pwede, pero hindi siya gaya ng relatives by consanguinity na within fourth civil degree na kasama yung cousins, for example. Dito, yung pwede lang kapag in-laws mo are your parents-in-law, your children-in-law, and your siblings-in-law. Next naman is defense of a stranger. Yes, you can defend a stranger and it can be appreciated as a justifying circumstance. Pero may requisites. Yung sa defense of relatives pala, yung requisites is same lang din. Unlawful aggression on the part of the victim, reasonable necessity of means employed to prevent or repel such aggression on the part of the offender, and the lack of sufficient provocation on the part of the relative that's being defended in case of provocation, or in case of provocation, kung nagbigay mo ng provocation yung dinedefend mong relative, the person making the defense, yung offender in this case, had no part in such provocation. So let's go to defense of stranger. So, pwede as long as, ito naman yung requisites, kahit wala sila dun sa list ng defense of relatives. May unlawful aggression ulit. So, sa tatlong to, merong unlawful aggression dapat as against the offender, or kung sa defense of relatives, as against the relative, or kung sa stranger, as against the stranger din. And that there's reasonable necessity of means employed to prevent or repel it, same lang. Pero last, ito yung nag-iba. The person defending was not induced by revenge, resentment, or other evil motive. So, talagang pure na dinefend niya lang yung stranger. Wala siyang personal reason to attack the victim. Okay, when I say victim, it refers to the victim of the crime. Kasi merong crime dapat, kaso because pasok siya sa mga requirements na to, like self-defense, defense of a relative, defense of stranger, at meron lahat ng requisites, so any dyan, kahit may crime, nawawalang bisa siya. So, hindi siya ititreat as crime, and hindi ititreat na criminal yung offender. Pero absent this, there would have been a crime. So yun lang yung yung pag-explain ko. I just used the term victim, crime, ganyan. Pero in effect, if may justifying circumstance, walang crime kasi walang liability here. Next, justifying circumstance is avoidance of greater evil or injury. Ito yung mention ko earlier. So, yung requisites are, there is an evil sought to be avoided that actually exists. Hindi pa rin imagined evil lang. So, there must be an actual evil. And that the evil or injury must not have been produced by the one invoking the justifying circumstance. So, of course, the person making the defense. Okay? The person who did something to avoid a greater evil or injury. Dapat hindi rin siya yung cause ng such evil or injury. And that there is lack of sufficient provocation on the part of tama ba to? Parang mali yung notes ko dito. Sa avoidance of greater evil or injury, wait lang, let me just check real quick para accurate tayo. Sorry about this. Okay, that the injury feared be greater than that done to avoid it. Sabi na nga ba, may mali sa notes ko eh. Ayun. So, ayun, dapat, ginawa mo yung something, okay, gumawa ka ng crime dahil iniiwasan mo mangyari yung something more devastating. Hindi pwedeng gumawa ka ng crime tapos yung iniiwasan mo something menial lang naman kasi useless yun, diba? Parang, kumbaga, you were doing good na for trying to avoid something that would cause great injury. So the person accused incurs civil liability despite the justifying circumstance. The said liability is borne by the person benefited by the act, not necessarily the accused. The evil contemplated includes injury to persons and damage to property. This greater evil must not be brought about by the negligence or imprudence of the accused. So next justifying circumstance is fulfillment of duty or lawful exercise of right or office. So yung requisites, the offender acted in performance of a duty or, dalawa to, in the lawful exercise of a right or office, and the injury caused or the offense committed be the necessary consequence of the due performance of duty or the lawful exercise of such right or office. So, wala siyang liability kasi legal yung ginagawa niya. Fino-fulfill niya lang yung duty niya or ina-exercise niya lang yung right or office niya. Of a right or office. So, hindi right of office, right or office. And dahil ginagawa niya to, may mga consequences. And sometimes yung consequence could be a crime, pero wala siyang liability in this case because it's a justifying circumstance. It's just fair. Lastly, obedience to an order issued for some lawful purpose. So, the order must have been issued by a superior. The order is for some lawful purpose. So, pag sinabi ng superior mo na pumatay ka dyan ng tao for like nothing, syempre hindi yun pasok dito. And the means used to carry it out must be lawful. So, yung example nito, kapag ka, for example, member ka ng military and then meron kayong, for example, kunwari, sinabihan na kailangan yung i-hunt down yung certain terrorist, diba? So, killing the terrorist, dead or alive. So, killing the terrorist is still killing a person, which would constitute as like homicide or murder, diba? But then, it is in the course of their duty and it has been ordered by their superior. And so, hindi sila pwedeng ikulong for carrying out such order. And the order naman is lawful because it's for national security, for example. Okay. So, idadagdag ko dito yung battered woman syndrome. Kasi, actually, disclaimer lang, sa battered woman syndrome, special siya na kind ng circumstance. It is a class of its own, sabi ni Justice Tang sa amin in class before. And yung pinaka-case nito is yung Henosa case. So, yun, kailangan i-read yun in its original para mas maintindihan natin yung concept ng battered woman syndrome. Pero in a way, para siyang justifying circumstance. Kasi, explain ko later, pero dati, parang kailangan self-defense. Pero, in the form of self-defense. Pero, may vowsy na kasi ngayon, and nag-iba na, kumbaga, yung paggamit sa battered woman syndrome. So, first, what is battery? An act of inflicting physical harm upon a woman or her child, resulting to physical, psychological, or emotional distress. So, hindi kailangan physical violence. A battered woman is a woman who is repeatedly subject to any forceful, physical, or psychological behavior by a man in order to coerce her to do something he wants her to do without concern for her rights. Battered women include wives or women in any form of intimate relationship with men. So, hindi kailangang hindi kailangan married, hindi kailangan may marital relations. It's enough that they have a sexual relationship or that they have a dating relationship. Furthermore, in order to be classified as a battered woman, the couple must go through the battering cycle at least twice. So what is this BWS or battered woman syndrome? It's a scientifically defined pattern of psychological and behavioral symptoms found in women living in battering relationships as a result of cumulative abuse. This is a defense that has the effect of a justifying circumstance, but it is sui generis really. So ito yung sinabi ko, parang it's a class of its own. So, battered woman syndrome as a defense. Victim survivors who are found by the courts to be suffering from battered woman syndrome do not incur any criminal and civil liability, notwithstanding the absence of any of the elements for justifying circumstances of self-defense under the RPC. So, this is the new rule na. In the determination of the state of mind of the woman who was suffering from battered woman syndrome at the time of the commission of the crime, the courts shall be assisted by expert psychiatrists or psychologists. So, in a way, it's kaya siya sui generis kasi parang siyang exempting circumstance, na justifying circumstance. So, elements of self-defense on account of battered woman syndrome. First is that each of the phases of the cycle of violence must be proven to have characterized at least 2 battering episodes between the appellant and her intimate partner. Yung appellant, ito yung babae, yung victim. Yung victim survivor. Pero yung victim ng crime, of course, kung meron, is usually the man, okay, the intimate partner. Next is that the final acute battering episode preceding the killing of the batterer, if killing yung dito, must have produced in the battered person's mind an actual fear of an imminent harm from her batterer and an honest belief that she needed to use force in order to save her life, and at the time of the killing, the batterer must have posed probable, not necessarily immediate and actual, grave harm to the accused based on the history of violence perpetrated by the former against the latter. So, ano yung cycle of violence? So, each cycle has 3 phases. We have the tension-building phase, and then the acute battering incident, and then the tranquil, loving phase, or also known as the non-violent phase. So, tension-building phase is when minor battering occurs and the woman usually tries to pacify the batterer to prevent escalation of violence. Next is the acute battering incident, when there is brutality, destructiveness, and sometimes death, and the woman believes it is futile to fight back based on past painful experience. Pero may trauma. And lastly, the tranquil, loving, or non-violent phase is when the batterer begs for her forgiveness, the victim survivor, and the woman tries to convince herself that the battery will never happen again. So, parang papatawarin na naman yan, tapos uulit na naman, kasi di naman nagbabago, di ba? So, Hinosa ruling is abandoned by RA 9262. Under the Hinosa ruling, battered wife syndrome is valid as a defense only when all the requisites of self-defense are present. However, Section 26 of RA 9262 abandons the precedent set by Hinosa case, which states that victim survivors who are found by the courts to be suffering from battered woman syndrome do not incur any criminal and civil liability, notwithstanding the absence of any elements for justifying circumstances of self-defense under the RPC. So, ito yung bagong ruling. A single act of sending an offensive picture, for example, constitutes violence against women. Under Section 3 of RA 9262, a single act of harassment would be enough since the objective of the law is to protect women and children. So, vowsy may be committed by any person, including a woman. So, yung batterer dito, or yung batterer, hindi kailangan man lang. So, pwedeng i-invoke ng woman, yung battered woman syndrome, against another woman. So, for example, nasa lesbian relationship sila, di ba? So, may isa na ina-abuse at may isang abuser. So, pwedeng i-invoke ng ina-abuse yung battered woman syndrome against a fellow woman na abuser niya. The law states that it may be committed against a woman with whom the person has or had sexual or dating relationship. Of course, hindi pwedeng marital relationship because they can't get married, diba? The use of the gender-neutral word person signifies that the law also encompasses lesbian relationships. Usually, man lang yung term ko kanina kasi usually man. Pero to clarify, pwede i-invoke yung battered woman syndrome against a woman as well. So, only convincing evidence is required to establish elements of self-defense. So, dito tayo ulit sa self-defense. It must be stressed that the defense is not required to prove with absolute certainty the facts constituting its defense. The accused is required only to prove by clear and convincing evidence the justifying circumstances he has invoked. Clear and convincing evidence has been described as more than mere preponderance, but the proof required is less than that required of proof beyond reasonable doubt. So, nasa gitna siya. Defense of person. Acting in defense of his person, be yourself, is based from one of the elemental instinct of humans to survive. When you defend your rights, pwede din yun sa self-defense. It includes all civil, political, and natural rights in addition to those embraced in defense of person, property, and honor, which other rights are recognized and protected by law. Defense of property naman is a defense of property rights which can be invoked if there is an attack upon the property, although it is not coupled with an attack upon the person of the owner of the premises, so long as all elements of justification must, however, be present. Defense of honor is a defense made if it is from the moment of aggression. It is the only means left to protect one's honor. So, yung defense of honor, yung case dito yung Haurige yata, pero dito hindi na-appreciate eh. So, kailangan meron pa ring aggression. And for example, i-rapin ka na, diba? So that pwede kang mag-self-defense para hindi ka ma-rape. And justifying circumstances kasi you're defending your honor. Unlawful aggression. There is an unlawful aggression on the part of the victim when he puts in actual or imminent danger the life, limb, or right of the person invoking self-defense. There must be actual physical force or actual use of weapon. It is an indispensable element of self-defense, whether complete or incomplete under Articles 11 or 13 of the RPC, respectively. Okay, wait lang. Okay. So, nasa na tayo? It is, unlawful aggression is the peril to one's life, limb, or right, which is actual and imminent. It presupposes actual, sudden, and unexpected attack or imminent danger thereof, not merely threatening or intimidating attitude. So, hindi pasok kapag parang threat or intimidation lang. So, actual or material unlawful aggression means an attack with physical force or weapon. Imminent unlawful aggression means an attack that is impending or at the point of happening. It must not consist in a mere threatening attitude lang, kulang yon. Nor must it be merely imaginary, but it must be offensive and positively strong. And the aggression, of course, must be unlawful, and it must be a continuing circumstance or must have been existing at the time that the defense is made. Retaliation is not allowed when unlawful aggression ceases, except when the aggressor retreats to obtain a more advantageous position to ensure the success of the initial attack, unless unlawful aggression is deemed to continue. So, for example, merong unlawful aggression against you. So, you defend yourself. Whatever the consequences of yung pagde-defend mo ng sarili mo, as long as it's reasonable, and hindi ka impelled by some other motive, justifying circumstance yan. However, kapag may aggression against you, and then nag-stop naman, okay na. Tapos, you still hurt the person making the aggression, diba? Or nag-commit ka ng crime against sa kanya, nag-cease na yung aggression, hindi na yan pasok. Kasi kailangan immediate. Kasi, kapag may ginawang masama sa yung tao, ano yung gagawin mo dapat? Not to kill the person who offended you. Not to take justice upon your own hands. But to report it to the authorities, to resort to legal means, ganun dapat. Picking up a weapon is unlawful aggression. If mere picking up of the weapon, not. Pero, if you pick up the weapon and the circumstances show that there is intention to harm the defendant, then that could be unlawful aggression. Mere belief of an impending attack is not sufficient, but in relation to mistake of fact, the belief of the accused may be considered in determining the existence of unlawful aggression. So, na-discuss natin before yung Achong case yata. Considerations in determining existence of unlawful aggression, again, may physical and objective circumstance, lack of motive of the person defending himself, and conduct of the accused immediately after the incident. So, ito yung mga kinoconsider na factors. In judging pleas of self-defense in defense of stranger, the court should not demand that the accused conduct himself with the poise of a person not under imminent threat or of fatal harm. So, syempre, ko consider nagpapanik siya at that time, diba? Hindi naman na parang level-headed siya kasi given the situation, syempre, filled with emotions na yan and adrenaline. So, usually, the person making the defense has no time to reflect and to reason out his responses. Yeah, he has to be quick. And his responses should be commensurate to the imminent harm. This is the only way to judge the person making the defense. For the law of nature, the foundation of the privilege to use all reasonable means to repel an aggression that endangers one's own life and the lives of others, do not require him to use unerring judgment when he had the reasonable grounds to believe himself in apparent danger of losing his life or suffering great bodily injury. So the test is whether his subjective belief as to the imminence and seriousness of the danger was reasonable or not, and the reasonableness of his belief must be viewed from his standpoint at the time he reacted. Okay. So, the right of a person to take life in self-defense arises from his belief in the necessity for doing so, and his belief and the reasonableness thereof are to be judged in light of the circumstances as they then appeared to him, not in the light of the circumstances as they would appear to others, or based on the belief that others may or might entertain as to the nature and imminence of the danger and the necessity to kill. There is no unlawful aggression in the following circumstances. First, when there is an agreement to fight and the challenge to fight was accepted, except when the aggression which is ahead of an agreed time or place is unlawful. Another is when the paramour kills the offended husband or spouse who was assaulting him because of the husband's aggression, because the husband's aggression was lawful. And lastly, reasonable force made by a police officer to arrest a suspect. So, yon. Ang sa last is, kapag yung officer making the arrest, hindi considered unlawful aggression yung arrest niya towards the person being arrested, of course. What is the stand your ground principle? A person is justified in the use of deadly force and does not have a duty to retreat if he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself or herself. So, doctrine of rational equivalence. Reasonable necessity of the means employed does not imply material commensurability between the means of attack and defense. What the law requires is rational equivalence, which is determined by the emergency and imminent danger to which the person is exposed and the instinct, more than the reason that moves or impels the defense. The proportion thereof does not depend upon the harm done, but rests upon the imminent danger of such injury. So, hindi mo siya titignan as weapon. Like, for example, i-compare mo knife versus gun or something. What if yung gun na lang available sa kanya, di ba? So, rational equivalence presupposes the consideration not only of the nature and quality of the weapons used by the defender and the assailant, but of the totality of the circumstances surrounding the defense vis-a-vis the unlawful aggression. As to whether the means employed is in proportion to the harm done, does not depend on the harm done, but the imminent danger of such injury. Perfect equality between the weapon used by the one defending himself and that of the aggressor is not required, nor is the material commensurability between the means of attack and defense. Rational equivalence is enough. So the test of reasonableness of means employed to prevent or repel the aggression depends upon the nature and quality of the weapon used by the aggressor, aggressor's physical condition, character, size, and other circumstances of those of the person defending himself, and the place and occasion of the assault. Parang napagod na ako dun Okay, doctrine of self-help. It allows the owner or lawful possessor of a thing to exclude any person from the enjoyment and disposal thereof. For this purpose, he may use such force as may be reasonably necessary to repel or prevent an actual or threatened unlawful physical invasion or usurpation of his property. Lack of sufficient provocation naman is that dapat there may have been provocation, but it should not be sufficient, quote unquote, and it must not immediately precede the act. So, anong requisites ng sufficient provocation? So, dapat walang sufficient provocation kasi on the part of the person making defense. Dapat wala, ha? Dapat wala. So, kailan ba may sufficient provocation? If walang provocation at all was given to the aggressor by the person defending himself, even if a provocation was given, it was not sufficient. Even if the provocation was sufficient, it was not given by the person defending himself. Even if a provocation was given, it was not proximate immediate. Ano to? Mali. Yung sinasabi ko dito is yung requisites na walang sufficient provocation. Meaning kapag walang provocation on the part of the person making the defense, justifying siya. So, okay, defense of relatives. It is founded upon a humanitarian sentiment, but also upon the impulse of blood, which impels men to rush on the occasion of great perils to the rescue of those close to them by ties of blood. The death of one's spouse does not terminate the relationship by affinity established between the surviving spouse and the blood relatives of the deceased. Sa defense of stranger naman, the ordinary person would not stand idly by and see his companion or any person killed without attempting to save his life. So, ano to mga ratio kung bakit may ganito? The person who defends another should not have acted from an impulse of resentment, because this is a time when motive becomes relevant sa kind of defense na to. So, euthanasia or mercy killing is condemned by law, although motive may be to spare a hopeless patient from prolonged suffering. The killing could not be justified as evidence of a greater evil, since ending the life of a patient is considered by law as a greater evil than his physical suffering. Okay, so marami tayong cases about justifying circumstance. Basta, if alam natin yung requisites ng mga defenses or ng mga justifying circumstance, we're good. It's quite, it's not difficult. Okay, so yung exempting circumstance, in the next video ko na lang siya. Okay, thank you.